Hi, everyone. My name is Shelley Menino-Morosi. I'm a Senior Director of Service Delivery at MiHIN, and on behalf of MiHIN, it's my pleasure to welcome you to the 11th Annual Connecting Michigan for Health Conference. It's great to see so many familiar and new faces this year, and we hope you enjoy the next 2 days as we hear from our great panel of speakers assembled from here in Michigan and across our great nation. Thank you to our breakfast sponsor, PCE Systems. We enjoyed breakfast very much. I'd also like to extend a special thank you to all of our sponsors, our attendees, our speakers, Michigan HIMSS, and the state of Michigan for your support, attendance, and participation. 2 quick housekeeping items. In case of emergency, exit to either the left or the right of the stage. Move in an orderly fashion to the main entrance of the building. Also, bathrooms are located in the main concourse area. Please check your program for a map of the Lansing Center. Today, Connecting Michigan for Health marks its 11th year. 11 years gathering healthcare leaders and change makers. 11 years of sharing, discussing, and inspiring the innovative next steps around exchanging health information. Our theme this year is Amplify, boosting the power of connectivity. It's time to build on the breakthroughs and innovations throughout Michigan and engage with the capabilities here. The statewide infrastructure and many of its services are ready. Michigan is seen as a leader across the nation with our statewide infrastructure and different services and use cases. Hopefully over these next 2 days, you will discover something new about what's available in Michigan and become a part of it. This year's annual conference also included a Connect-a-thon held at the Motor City Casino in Detroit. Last week and yesterday, we had a legal summit here in Lansing. Both events in their second year have seen groundbreaking developments born and complex legal issues discussed. We invite you to actively participate in this year's conference by asking our speakers questions and engaging with us on social media. If you don't follow MiHIN on Twitter, please do so. Detailed information on hashtags and more can be found on page 13 of your program. To get us started, we will hear a view from the Office of the National Coordinator. Elise Sweeney Anthony serves as the Executive Director of Policy at the ONC. Ms. Anthony leads ONC's engagement on a range of high-priority federal policy efforts, including regulatory development, information blocking, macro implementation, and governance. Her portfolio also includes emerging issues and health IT policy matters impacting EHR incentive program participants and other care settings. Prior to this position, she served as Deputy Director of Policy, where she led the Division of Strategic Policy, the Division of State and Interoperability Policy, and the Division of Federal Policy and Regulatory Affairs. She also led ONC's coordination with CMS on the EHR incentive program regulations, including the 2014 CERT flexibility rule and the stage 3 and modifications to meaningful use in 2015 through 2017 final rule. Ms. Anthony is also an experienced health policy attorney and advisor. She spent many years at a leading law firm where she spearheaded a variety of health improvement initiatives, including initiatives impacting care delivery, health innovation, and at-risk rural populations. In addition, she has served as a senior director at a global consultancy where she focused on health improvement and international conflict zones, on addressing health disparities in developing regions. She has led initiatives across the policy landscape, including with Congress, the United Nations, and the World Health Organization. How lucky are we to have her here in Michigan this morning? Please join me in welcoming Elise Sweeney Anthony.
Good morning, everyone. How are you today? Welcome to the MiHIN conference. We're excited to be here. I'm going to open up this water because, don't mind me, I'm getting over a cold, so just bear with me if I start coughing uncontrollably. All right, so my name is Elise Anthony. Thank you for that wonderful introduction. It's a pleasure to be here. As you can imagine, it's been an exciting time for us here at ONC. There's several of my colleagues are here. John Raincourt, who leads my division on interoperability, focused a lot on Tesca, as well as state engagement, as well as Dr. Andy Gettinger, who leads our clinical team. So I just want to give a shout out to some of our folks here as well. I had the pleasure of being here yesterday for the Legal Summit, and it was quite a joy. As a lawyer by trade, it is always great to be in a room with other folks who care about the things that I care about, the minutia of it all, which is something that us lawyers love. At the same time, at ONC, I work on broad policy as well. So not only thinking about some of the legal constructs that need to be in place to support exchange, to support the movement of electronic health information, that includes fun things like the rule, which I'm sure everybody put in comments on yesterday, right? Of course. Yes, all right. So for those who want to take a quick guess at how many comments we have in so far, anybody know? I hear 1,000. Higher? No, not 10,000. We have about 1,800 comments in already. We're really excited about that. So I will tell you, as a policy person who works in DC every day to try to bring to bear what needs to happen on the ground and to support what you guys are seeing as the needs, it is such a pleasure. It's so exciting to see so much engagement in the public comment process. For those of you who have heard me speak before, I always talk about, my PSA is always comment, engage, let us know, tell us what you think, good and bad. So I was literally going through the comments last night, and we do read every comment. Going through the comments, and it's just amazing to see the feedback that we've gotten. Folks telling us where we got it right, folks telling us, where we missed the mark a little bit, where a little bit of clarity would be helpful. And all of those things are part of the public comment process. That's why we have it, to make sure that we're understanding the impact, to make sure that we are clear on the definitions we are setting up and the goals we're trying to achieve. And through receiving that comment, now it comes back to my team to think through how to turn that into a final rule. So we take into consideration all the comments that we've received, and we work across HHS and the administration to think through the goals. And of course, Dr. Rucker, who is an amazing leader, who has led us on this journey of releasing the proposed rule, as well as other great items that we've put out, like the clinician burden report draft and draft Tesca as well. So today, we're going to focus a little bit on two of those areas. We're going to focus a little bit on what's in the rule, as well as what's in Tesca Draft 2. Now, I did say I'm a lawyer, so what does that mean? Any disclaimer? Great. Okay, so here we go with the disclaimer. So as we present on the rule, I have to say any comments you make, or things you say throughout the day, we can't take that into consideration. We can only take into consideration what came in through the public comment process. That also means that I have to be pretty limited in terms of what I talk about. I can only talk about what's in the rule. I can't interpret beyond what's in the rule. I can only talk about the specifics that are there. So bear with me. Don't throw any rotten tomatoes at me or anything like that. Part of the job. All right, so let's talk a little bit about the rule. So one of the things that we've been focused on at ONC is not just having the right policies in place for folks to react to, which is paramount, but also making sure that we put those out in a consumable way. So not only did we put out the rule, but we also put out a series of infographics and info sheets to help people take a look at and identify what's important to them, which can be, hopefully, was a starting point for you to dig deeper into the rule. So even though the comment period is closed, if you want to dig deeper into what we have in the rule, into specific areas, you can take a look at this page. It's healthit.gov/NPRM. It's one of my favorite pages, as you can imagine. I have another one, Tesca, later on, but we'll talk about that. But this page really highlights a number of the materials that we have that you can take a look at to really get a look at what's in the rule. And if you look on that right-hand side, we also have 4 webinars that we did. And the audio is available online. You can take a look and go through it and really get a feel for what's in there. So we have one on information blocking. We have a general one. We have somewhat of a question and answer one. And then we have one that one of my colleagues did, Steve Posnack, on APIs, application programming interfaces, and what that looks like and what we're thinking about for the purposes of the rule. So take a look here. Now, this is also a good way for you to read the comments too. If you want to take a look at the comments that are in there, you can go through this website and it will take you to regulations.gov. Or you can go straight to regulations.gov and put in something like ONC, information blocking rule, and it should pop up. All right, so now let's talk a little bit about what's in the rule, what our focus has been. So Dr. Rucker talks a lot about the importance of supporting innovation and competition. So in the rule, there's a number of provisions that are designed to do just that. And when we say innovation and competition, we're not just talking about new folks, new entrants, which is important as well. And it's a key part of what we're doing, thinking about app developers and those engaged across the ecosystem that supports electronic health information for the benefit of the patient and the providers who serve them. But we're also talking about innovation from legacy as well. So those who have been in the environment for some time, there's always opportunities to innovate. So we think about that across the landscape. We want to support an environment where innovation can occur, where things like application programming interfaces can shine and provide new opportunities for patients and providers, for example, to get the information they need in a way that works for them. We're seeing some of that innovation happening, but we think that having secure and standardized application programming interfaces will take it to a new level. And that's some of what you'll see in the innovation and competition kind of themes that you see across the rule. Second is reducing burden and interoperability. And here, let me just highlight before I talk about the rule, I do want to give a quick shout out to Dr. Gettinger, who is here somewhere, Dr. Gettinger, who lays the work on the clinician burden report. There he is in the back. And one of the parts of the clinician burden report that comes actually from the Cures Act is that Congress wanted us to think about how to support the needs of providers and to think about how to reduce burden in that realm. And we put out a draft report, and we heard a lot back in the comments. The comments are actually up on our website. Take a look at those as well. And we're now thinking about how do we finalize that? What can we do, not only at ONC, but across the HHS landscape, including at CMS. Within the rule, we also think about reducing burden, how APIs can help improve the workflows, for example, for providers, and also the advantage of interoperability in that construct. So where information is moving and duplication is not necessary, and a provider has what they need, even if that patient information doesn't exist in their system, but might exist at, for example, the dermatologist across the country where that patient was also seen. So we think about the connectivity and how to support that within the rule. And then promoting patient access. And this is something that you'll see across the rule when you look at the themes. And this is really important because in 4006, which is one of the provisions in the 21st Century Cures Act, Congress asked us, along with OCR, to think about how to support patient access, how to support the education of patients regarding how to get their information. And there's some things we've done already, and I will talk about those later, but even throughout the rule, you see that. There's one section in our conditions of certification where we call out the ability of a patient to go to a provider and be able to get their entire record, and how to pull that down, and the fact that a data dictionary also needs to exist in that construct. So throughout the rule, you'll see patient access, including in the information blocking section, where we talk about where a patient is requesting their electronic health information, electronically, and those are the key words, that should be at no cost. So we include provisions related to that as well. All right, so let's highlight a little bit more specifically about what's in the rule. So how many folks are familiar with the Common Clinical Data Set? Yeah, well, pretty good, pretty good. I work in a technical environment, so anytime I see people raise their hand for technical standards, I get very excited. The Common Clinical Data Set is what many folks may know from our previous rule. The 2015 edition is our previous rule that focuses on the technical standards. And what Congress asked us to do was to really think a little bit more broadly about how to ensure that health IT developers that are coming to ONC to be certified are actually in the place they need to be to not only have the technical components, but also that their business practices are tracking on what needs to happen to support interoperability, patient access, or access exchange and use of electronic health information. And this is one of the components that we think is critical. So the US CDI would be the update to the Common Clinical Data Set. And it's a set of information that we think is critical to be able to move, to be able to be exchanged. And the US CDI, the United States Core Data for Interoperability, would be a standard. And it builds upon the Common Clinical Data Set, but you see there are some additions here. So one is provenance, clinical notes, for example, are some of the other updates that we focus on. Excuse me, as promised, there's the first one. Okay. So when we think about the US CDI, we also put in a provision that would allow us to update it on a more timely basis. One of the things with rulemaking, as many folks know from, for example, our previous 2015 edition or 2014 edition, that the rulemaking process can take some time. No shocker there. And there's a reason for that. One of the things we put in the rule is a standard versioning update process, as it were. And that update process would allow a certified developer to version up to a new version of a particular standard. And once they decide to do that, they would be held accountable to that. But we think that's a good way for us to move in time with industry, particularly in technology where standards can move pretty quickly. And we don't want our program to be in a position where we are holding back the innovation that can occur. So through this versioning update or versioning advancement process, we would be able to allow certified developers to do just that. And we seek comment on that as well as all things in the rules. So we're looking forward to starting to go through those comments in particular. All right, so I talked a little bit about the conditions and maintenance of certification, and I think this is a key point, right? So we want to make sure that our certification program, so keep in mind, what is a certification program? So pretty much a health IT developer can come to us and say, I want to be certified to X criteria. I support providers in this landscape, and this is something that they need for their systems, so it allows them to be certified to that. Our program is pretty much a program that allows for a certified developer to create the puzzle picture that they need to support providers, right? Sometimes we refer to it as a buffet, where you can pull off the buffet what you need in terms of certification criteria and create the product that benefits the providers and the patients that you serve. What Congress asks us to do is, in recognition that business practices impact interoperability, and that things like the ability of the product to operate on the ground need to be paramount, that they added in these specific conditions and maintenance of certification through the 21st Century Cures Act. And our job as an agency is to bring those to life, to add the regulatory structure to support their implementation. So we'll talk about information blocking a little bit later, but I think it is key to note that Congress identified information blocking as a condition of certification, as well as including an entire 4004 section just on information blocking. So Congress has said, as a certified health IT developer, you cannot information block. And that's pretty much what that provision says. So we include the follow-on components to that. Now, the insurances we'll talk about on the next slide, which is, and there's several components to that, but one is around what we call a patient export criterion. And then communications. Congress heard a lot about health IT developers who might have been having in place what some refer to as gag clauses, or clauses that prohibit communication about how the product is doing. And the communications component that we've included here says that you can't do that. If you are a certified health IT developer, then you have to allow for that communication to occur. So if I'm a provider and I see something on my screen and I have some concerns about, how that's displaying the information, whether it's safety, usability, that I have the ability to talk about that, to share that information, to engage with others so that we can discuss how the concerns that might exist. And some contracts we've heard don't allow that to occur. So under this provision, that would not be allowed. And we talk about things like screenshots. Now, there's some limitations when we think about intellectual property, but it allows for that information to be shared in a more ready format. 4 is application programming interfaces. Now, as I said when I talked earlier about the webinars, keep in mind that under each and every one of these provisions, there is literally, I could talk for an hour on every one. Between Tesca is usually about an hour presentation, and the rule is usually like an hour, hour and 15. So I'm going to try to give a highlight, but I do encourage everyone to go and take a look at our website where you can get much more of a deeper look at many of these provisions. So application programming interfaces, how many folks know what those are? All right, well, we use them every day. Awesome. So my favorite example is if you want to go and watch your favorite show online, and you might go to whatever the local channel is, and they ask you to put in your TV provider's information, right? You put in your username and your password. That's an example of an API. So it's pretty much what we've put in our rule is a secure door that can be opened to access the electronic health information. Now, it's not, as Dr. Rucker would say, it's not a barn door. It's not swinging opening in the wind. It's a secure, standardized door that allows for information to be accessed, not in a more ready format, number one, and two, presumably by folks who are putting together interesting applications or interesting functions that take that information and can present it in ways that are beneficial to those who need it most. So we talk about application programming interfaces, and there's many provisions in the rule that are focused on what we call the without special effort requirement of Congress. So Congress says that application programming interfaces should be available without special effort. So we include provisions around fees and what fees can be charged. We include provisions around what the application programming interface has to look like and how developers have to make it available for use by those who would need to use it. So that is, I think, webinar 2, if I remember correctly. But it's a wonderful look, if you take a look at that webinar, about what we're thinking and how without special effort can come to life to really make it easier and, I think, more accessible in terms of accessing information. Now, real-world testing, so what is that? So what our program does is we test to make sure that the products are able to do what they say they're able to do. Now, we, in the real-world testing provision, take that to another step, which means that certified developers have to ensure that the products are not only doing what they're supposed to do in the labs when tested, or when a accredited certification body is taking a look at the particular provision or certification criteria that's in place, but also on the ground. They have to be, the products have to be able to do what they're supposed to do when they're on the ground. And this is something we've heard a lot about from providers over the years, right? So the product says it's going to do X, but when it gets into the live environment, it doesn't actually come to bear. So that's something we wanted to address, and we built out a provision that we think will bring that to life. But again, we're looking forward to going through all the comments on whether we've hit the right notes on that. So attestations includes several provisions, but the idea is that we want to make sure that certified health IT developers are attesting that these conditions and maintenance of certification requirements are being met. And that also is part of our enforcement capabilities to make sure that, again, where they're saying that the products are meeting these conditions and maintenance of certification requirements, that they are in fact doing so. And the last one is electronic health record reporting program. And this one is highlighted in blue for a reason. There's a whole nother section in Cures, and by the way, I should say most of our work lives in Title IV. So in Title IV, there's another section on electronic health reporting, an electronic health record reporting program. And what that focuses on is making information criteria available about how a product is doing. So certain information that a certified health IT developer would have to report on and say, this is what our product does. And it also might be users as well. Users who are saying, this is my experience with the product. And what Congress asked us to do is to put together, one, what those criteria are, and then set up a program where that information can be accessible. One of our other policy efforts was last summer was to put out a request for information on this program specifically, to hear from stakeholders what would be helpful to know, whether you're a developer and what you want to share in terms of your product, and perhaps if you're a user, what would you want to know about that product? And that information is being used by us to really work with a contractor to identify what that criteria is going to be. So once that is set up, then that is also something that the health IT developers who are certified under our program would be held to. So that's why that one's highlighted. All right, so electronic health information export criterion. Now, long title, but 2 key use cases that we support. Our goal here is to make sure that if you are a provider and you're using a certified health IT developer product, that you are able to get the information you need. So there's 2 key use cases that are supported that we've heard. So one is switching. You're a developer, you're a user, you're a provider, for example, whether you're a hospital system or a small rural provider, and you've purchased a health IT system, doesn't exactly do what you need to do now. That could be for several reasons that I'm sure everyone in this room can tell me stories about. But you are using a particular product, it's not doing what you need it to do, so you decide you need a new system. And we've heard a lot of stories about the information getting, quote unquote, locked up in systems or not being easily transportable to the new system that you want to work with. We did a contract guide a few years ago, which is a great resource. Check it out. It's on our Health IT Playbook, and basically it's a resource for providers who can take a look and think through some of the contracting questions that can help inform them when they're sitting across a negotiation table. And I always say it's not pitting developers versus users or providers, but it's really designed to be a resource for both parties, so folks can think through where each side is coming from when they're sitting at the negotiation table. And one of the things we talked about in that report is this concept of switching and what you need to be aware of when you're switching. So here we are now working on this rule to support cures, and we've thought about that here as well. So what the provision says basically that if a provider is switching, then they have to be able to move the electronic health information that's in that system over to another provider. And that has to come with a data dictionary. So the information has to be able to be pulled out, so the developer has to support that capability of that information to be able to move. But not just that, you have to include a data dictionary with it so that the system that's picking up that information knows how to place it and where it needs to go in the technical system. The second use case is when an individual is asking for their information. So if I'm a patient, and we're all patients, right? And I'm a patient and I'm going to my provider and I say, hey, I need all of my electronic health information. I want to pull it down. And maybe I want to put it in an app that I've chosen that I think is going to serve my needs. That information has to be pulled down. In the same construct, you have to make the data dictionary available as well, if necessary, to support where that information needs to go. So those are the two use cases. And again, this goes to patient access. This goes to supporting the needs of the provider, reducing clinician burden and trying to have these systems support their everyday life as providers. And that's the type of things that we think about at ONC. Okay, so pediatric care and practice settings. There's a specific provision in the Cures Act that calls for us to think about pediatric settings and to identify recommendations that would support a provider who is serving these patients. So what we've worked on is first starting with what's called the Children's EHR format, which was worked on by our partners at CMS, as well as at ARC. And that is kind of where we started from, as well as working with stakeholders and identifying what would be some recommendations that would support the pediatric care setting. And we came up with the recommendations that are laid out here. But we also looked at the 2015 edition. So the 2015 edition is our most current set of the technical requirements that a certified health IT developer would have to use. And that's finalized, that's in place. Many providers have moved to 2015 edition already. What we propose in this rule would be updates to that. But we looked at that 2015 edition and identified what are the criteria that we think would support pediatric settings. And we also looked at some new ones that are in this current rule that we think also would support pediatric settings. So those are things like we include data segmentation at a more granular level, for example, and the updates to the US CDI, the United States Core Data for Interoperability. I'm trying to cut down on the acronyms, but someone needs to hold me accountable because it's so easy to slip into that world. But the US Core Data for Interoperability is also one of the provisions that we've noted here. And we look forward to getting the feedback from the stakeholders through the comment process on whether we hit the mark, and then thinking through resources that we can make available for those developers that are supporting pediatric settings, but also specifically for the practices that are supporting pediatric care. All right, so now we get to talk about information blocking. Who's excited? Everyone's excited. So I've been working on information blocking pretty much since I came to ONC. In 2015 edition, we released the, 2015 edition. In 2015, we released the information blocking report. The information blocking report was requested by Congress for us to look at what is information blocking, how is it happening, what are the situations we're seeing on the ground. So we did a report that laid that out. Following that, as Congress was looking at the cures legislation, they included Section 4004. And I will tell you, I spent a good amount of time in Section 4004. Our advisory committee chair once, joked that that I sleep with Cures Act under my pillow. I will neither confirm nor deny. However, for purposes of 4004, 4004 is all about information blocking. And the general structure is that Congress places responsibilities with the Office of the Inspector General at HHS to look at, identify, and enforce information blocking under 4004. Now, I should note that under, as I mentioned, the conditions of certification, there is a component of information blocking that ONC would enforce, right, in terms of if you're a certified developer, are you information blocking? If you are, you might have a problem. We need to talk. But under 4004, it would be the Office of the Inspector General. And Congress does an amazing job throughout Title IV, but in 4004 as well, of laying out the definitions for information blocking, what the requirements are, what the enforcement looks like. It's very well laid out and very specific in terms of what Congress wants to see. Some of the things that I would note is there are two different definitions depending upon the type of actor you are. So if you are a healthcare provider, you can be an information blocker. And the standard there is that you knew. And for the lawyers in the room, or the lawyers that were here yesterday, know that there are different knowledge standards attached to things. The knowledge standard of did you know, right, is did you actually know that there was a problem with what you were doing? For the other three actors that Congress identifies, which are certified health IT developers, health information exchanges, and health information networks, that those three are held to a you should have known standard, which is a different standard. So when you're thinking about what is information blocking, one of the first things you need to look at is the definition that applies to you and whether you are an actor. So this is something that we really have put work into setting up the definitions of those four actors: healthcare providers, health information networks, health information exchanges, and certified health IT developers. One of the things that we sought comment on is whether those definitions hit the mark. So we're looking forward to receiving comment on whether those definitions should be more nuanced or whether they are appropriate in terms of their scope and breadth. So once you are defined as an actor, the next thing you would look at is a definition of electronic health information. So electronic health information is a term that we define, and we start by looking at the relevant definitions in HIPAA. And then we add on a layer related to the electronic use of that information. So it's electronic media. I should note that it's not de-identified information, it's identifiable information. But again, all of this is subject to feedback through comment. One thing I did want to note is if you look on that, let's see, eyes don't fail me now. If you look at the first red bullet, but the third sub-bullet, you see that the definition includes past, present, and future payment in the provision of health care to an individual. Now, this is one of the areas that we've received a lot of feedback on, and that's kind of price information. So not just that component, but there's a separate request for information in the rule around price information and how price information should be captured for purposes of information blocking, for purposes of electronic health information. And there's a lot to know here. And if you look at the section in the rule, there's a fair number of questions that we include, not only on behalf of ONC in terms of implementing and thinking through the definition, but also the department as a whole has been interested in this area. So we've included some questions that are relevant to the department around price information and how that's defined and what standards might exist to capture it. All of those are components that we think are important. And in the comments, as I said, I was going through them last night, a lot of them are from individuals who have concerns about not being able to access that information. So it's something that Dr. Rucker has been very focused on, and we'll be thinking through the request for information as we move through the process of reviewing the comments. But overall, here's a different definition for electronic health information. And this is the body of information that would be required to move if you are an actor. So if you're an actor, you should be moving this information unless you fall into what we call a reasonable or necessary exception. Excuse me. We're going to talk about the exceptions in a second. So I talked about the knowledge standard. Let me just highlight a little bit about the not covered by applicable law. Throughout the exceptions, you see that there are references to existing law, particularly in the privacy and security element and exception. And that's important because I do want to highlight how ONC approaches our work. We work very closely as the coordinator, which is in our name, not just amongst ONC and across the different offices at ONC, but also with CMS, with CDC, with the Office of Civil Rights, which manages implementation and enforcement of HIPAA. All of those entities were part of the process for us to release this rule. So our engagement across HHS has been critical, and it extends beyond HHS as well. You know, there's components where we've worked with the Federal Trade Commission to understand a little bit more about some of the spaces that are relevant there, as well as with entities such as Social Security Administration, for example. There's many components where we think about the broad intersection of our work across the landscape, and that's part of our coordinator role. All right, so now we know what it takes, what is kind of information blocking, we know who the actors are, we know what the electronic health information definition is, so let's talk a little bit about the exceptions. So this is where Congress asks us to focus a lot of our attention. So what are the exceptions? So pretty much the concept of exceptions are you are an actor, you are supposed to move the electronic health information, you did not move the electronic health information. Is the reason you didn't move it one of these exceptions? That's kind of the general structure. And as we put together these exceptions, we thought about what are the on-the-ground realities of information blocking, of interoperability, and what are the situations where information doesn't move because of an excuse, as it were. So I'm willing to move the information, but I want you to jump through these 8 hurdles to get the information. Or where is there legitimate reasons why the information didn't move? So all of those came to bear, and I should note that in the rule we included a specific request for information around, did we include all we needed to include? Are these set of 7 the right 7? Are they structured in a way that's effective? So all of those are components that we want to make sure we got right. Okay, so now what are the exceptions? Who knows them by heart besides me? No? Okay, no? Okay. I'm not offended, it's okay, it's all right. All right, so the exceptions. So the exceptions, there's different kind of ways to think about them, but let's focus on privacy, security, and safety first. And that's spread across several of the sections, as it were. And in those exceptions, we want to make sure that, you know, where there's a reason why the information didn't move because it might cause a harm or it could prevent a harm, or the information didn't move because there's a law that says it shouldn't move in relation to privacy or security, or that those are given as excuses for why information didn't move. That's not what we want. We don't want an environment where these exceptions are used in a way that's too broad. They're designed to be narrow exceptions that are available for the right particular use case and scenario, right? So under these exceptions, they're not just in high-level exception. Let's take privacy and security, for example. That privacy and security exception has 4 subsections, one of which has to be met. So they're very specific in terms of how they're laid out. And they allow for things like privacy and security, for example, allows for if you are respecting the individual's request not to share information. That could be a reason. Or there's an applicable law that says not to share the information. But you do see an overarching theme throughout our exceptions. Is your decision objective and verifiable? Is it non-discriminatory? Those are words you see across all of the exceptions in different places. Why? Because, for example, if you are a health system and you are sharing information without issue, the same set of information, the same set of circumstances with a provider who has privileges at your hospital. But when a provider who doesn't have privileges at your hospital comes to get the same information under the same set of circumstances for the same patient, for example, but you treat them differently, that would be something that we'd look at in terms of non-discriminatory, for example. Or whether your policies are objective in terms of how you're looking at the sharing of information. So those are things that you would see throughout the exceptions. There's also 2 exceptions that relate to fees in some ways. One is recovering reasonably excuse me, incurred costs or fees. And the other one is around licensing. Now, we heard a lot over the years around situations where, let's say, an entity is not saying you can't have the information for the patient you're serving, but they say, and this is just a random example, for example, it will be, in order for you to get the information, it will be $1 million interface, but I'm a rural provider. How can I get the information I need to serve the patients in that construct? Now, maybe you're saying for this provider who's doesn't have privileges at your hospital, it's $1 million fee for the interface for you to get the information. But if you are a provider who does have privileges at your hospital, it's $10. Now, that's an extreme scenario, but I wanted to highlight some of the examples that folks have said to us in terms of how fees are used to disparately treat the flow of information to those who need it, providers, for example. And we had many meetings with the Office of Inspector General where entities came in and gave examples around fees and how fees are used. So what we wanted to put in is an allowance for fees to be charged, but those fees would have to be reasonable. They would have to be reasonably incurred. They'd have to be related to the movement of information and not discriminatory, for example. In the licensing provision, we talk about we talk about information moving on reasonable and non-discriminatory terms, RAND terms. So you see that theme coming across in the exceptions. We understand that there are day-to-day needs where costs may be relevant or licensing may be relevant, but are those being applied in an objective way, in a verifiable way, in a way that is really related to the movement of information and not being used as an excuse for choosing where information goes or hoarding information, as folks sometimes say. There's also an exception related to the feasibility of movement of information. And the feasibility requirement is, there might be a situation where you're asked to have information move, but in that scenario, how the information would need to move is not feasible. But in that requirement, again, it's not designed for a truck to be driven through, for example. It's designed to be a narrow exception. So even in that scenario, using that exception would require that you look at other alternate means to get the information where it needs to go. And there's also one more that relates to system downtime, for example, where you're taking the system down, and we've heard that that's been used as information blocking in terms of not allowing the movement of information or not allowing switching from one system to another. So we've included an allowance for systems to be taken down, but some of the things that the Office of the Inspector General would look at in the application of this exception are things such as, did you allow for systems to be taken down in a similar way? Are there certain fact patterns that are being used where this demonstrates that the taking down of the system was really an excuse for not sharing information? And that's a good way for me to note that all of the exceptions in the information blocking section are about a case-by-case analysis that the Office of the Inspector General would apply. Now, why? Because we've heard that there are so many scenarios and how information blocking can occur that we wanted to provide enough specificity in terms of the definitions that Congress has laid out and the exceptions, but also allow for OI, Office of Inspector General, to look at the particular circumstances of each case to determine whether information blocking has occurred, and also who is responsible for the information blocking, right? Is it the provider, is it the developer, is it any of the other actors? Okay. So Tesca. So John Rancourt spent a lot of time talking about Tesca yesterday, so I wanted to provide an overview of Tesca generally. So the Trusted Exchange Framework and Common Agreement is not part of the rule. So I always have to say this because some people refer to the Tesca proposed rule, and it's not part of the rule. There is a request for comment on how we can think through the rule and Tesca, but the Trusted Exchange Framework and Common Agreement, Draft 2, is a separate document. It is available on our website, and we are receiving comments through our website. So the concept of Tesca is another requirement that Congress laid out, asking us to think through how we can support network-to-network exchange. So many of us know, and I always use my hands when I talk, so this is a perfect opportunity for me to do it, but there are many networks who are moving information, right? And they move information often well within their networks. But when it becomes time to move information across networks, there's a disconnect. And the disconnect may be because one network doesn't trust another network from a security perspective or a privacy perspective, or maybe the exchange purposes that one network supports is different from what another network supports. So that causes the disconnect, and there's that lack of trust that needs to exist. So what Congress asked us to do is to level that, to create the trust so that information can move across networks. And that's what we've designed with the Trusted Exchange Framework. We would have a recognized coordinating entity, and there is currently a cooperative agreement out, a notice of funding opportunity for us to identify a recognized coordinating entity who would help us operationalize the program. And they would work with ONC one-on-one, because there would only be one RCE, to help bring to life the Tesca ecosystem that we seek to create. And I love this slide because it highlights what that ecosystem looks like. So you have the RCE that's managing the operations, ensuring that information is actually moving where it's supposed to move, and in some cases correcting a situation where a QHIN, a Qualified Health Information Network, is not doing just that, for example. The QHINs would be specialized health information networks that are able to do certain things. They're able to move large bodies of information. They have record locator services to support that. And they would be able to pull information from where it exists across the landscape and get it to where it needs to go. Now, this ecosystem allows for a lot of flexibility. What we wanted to allow for was different levels where providers, networks, health information exchanges, developers could all exist and decide where works best for them. So you could decide to be a participant, which means you are underneath a health information network. You could decide to be a health information network, which means that you're working with a qualified health information network, a QHIN. You could decide to be a QHIN, which means you work directly with the RCEs. The landscape that we've created allows for the flexibility for folks who have been who are successfully in network exchange now or seek to be, can decide where they want to evolve, including app developers, including individuals who are also designed to participate in this environment. And the reason for that is we know that there's been a lot of progress. I noted before that our goal is to do this, where there's often this. Okay, so in that construct, we know that there are many successes that have happened in terms of information moving, often in terms of treatment. But maybe there's areas where that success needs to increase in other exchange purposes or across other networks. And that's what we're focused on. We want to take the successes that have happened to date and build upon those by addressing the gaps. And that's what we've done. We did it with our first kind of tell us what you think release that we did, and then in draft 1, and through all the wonderful comments that we received, the wonderful feedback, positive and negative, about how we can adjust it, we released draft 2 that updates a lot of those components. Okay, so here are the exchange purposes. So I'm a little over, so I'm going to speed up a little bit. All right, so treatment, of course, is included, but we also include some of the aspects of payment and operation for the movement of information, as well as individual access services. And I want to highlight that because in the environment we are in terms of accessing information, the individual is paramount. And the individual's ability to get their information is something you see not only in our rule, which I discussed earlier, but also in terms of Tesca. So there might be app developers who are interested in supporting individual access services and want to participate in the Tesca environment. And the way we've laid it out supports that landscape as well. And then benefits determination, which I always like to highlight because it's not exactly what some folks might think. Benefits determination relates to, for example, the Social Security Administration, who often needs to verify, excuse me, to verify health status for purposes of disability claims. We want to support an ecosystem that supports that as well. And again, this goes to interoperability being broader than what many of us have thought about over the years, and really supporting the whole individual and all of their needs that might exist. Okay. So Tesca, where can you find more? You know, I love my resources. This is not designed to read, so you don't have to read this. You just have to know where to go. And where do you go? healthit.gov/Tesca. And that's where you can find a user's guide that lays out, it's kind of like a PowerPoint, interactive PowerPoint, but it lays out information so that you can understand Tesca and how you can participate. The most valuable part of that user's guide, in my opinion, are the examples. And the examples specifically lay out how let's say a provider or how a payer or how a health information exchange can exist in the ecosystem and where they can exist and how that can work. So I would encourage folks to take a look at that as well. Tesca is out for public comment still, so I'm going to be very clear. The rule is closed. Yesterday it was closed. We're about at 1,800 plus comments now, but Tesca's still out there, June 17th, so please comment. If you go to healthit.gov/Tesca, you'll find a ton of information about Tesca, but also on how to comment, and we need to hear from you. In order for us to make this a reality, in order for us to take all of the lessons learned and the successes that we know can be achieved through Tesca, through network-to-network exchange, we need to hear from you, because we have to make sure that it's operational on the ground. I always say to my team, we could develop policy all day. But if it doesn't work on the ground, then we have not been successful. So all of the things we do around public comment, around the multiple public comments on Tesca, public comment on the rule, our Health Information Technology Advisory Committee, which anybody can participate on every single call. There's always a public comment component, so I always put that out there. All of those components are part of our ability to get it right. And we really take the feedback in. We really try to make sure that what we're doing is operationally possible, that it's helpful, that it meets the goals that Congress has asked us to do. So please engage wherever you can in those processes, because it feeds us. It feeds us in terms of having the information to make the right choice to support the needs of health information technology across the landscape. All right, so these are just some resources. I'm just going to put these out here because they're great resources on access, how to access information, how to support your patient's ability to access information. One of my favorites is there we go, is the Get It, Check It, Use It guide. And the Get It, Check It, Use It guide is a guide that helps patients understand how they can get their information, how they can use it once they have it, how they can even do patient amendments. And it also helps them to understand HIPAA in an easy way. I think I've created the term thumbable, but I might be lying. Someone else might have that. But it's thumbable in that you can look at it on your phone and you can scan through it to really understand. So if you're a provider, if you are an exchange, or if you work with patients in any format, it's a great way to say, hey, did you know you can access your electronic health information, and here's how, okay? Also, providers, there's a ton of information that we have available. OCR also recently released some updated frequently asked questions related to the movement of electronic health information, so I would encourage folks to take a look at that. I will be around all day, so if you guys have any questions or thoughts or things you'd want us to know, I'm happy to hear them. If it's on the rule, comment period is closed, but if it's on Tesca, I am totally for it. Let me know, okay? Other than that, there will be more to come. We always are open to engaging. My team is amazing, and we always want to make sure that we have an open door to anyone who wants to talk to us. So reach out, we're here, and thank you so much.